Hi, welcome to NAANDHI. If you find our content informative and useful, please like, share with your friends and fellow aspirants, comment, and do subscribe to our channel for more updates. In this session, we shall discuss about Section 66A of the Information Technology Act. What was it all about? Why and when it was struck down by the Supreme Court of India. Before that, let's see why this controversial Section 66A was in news despite it was struck down by the Supreme Court of India in 2015. Let's see. Supreme Court of India, while hearing a plea by an NGO called People Union for Civil Liberties PUCL on Monday, said it was terrible and distressing that nationwide application of Section 66A of the Information Technology Act to arrest persons for social media posts was still continuing 6 years after the court had erased it from the statute book for being violative of the right to free speech guaranteed under Article 19 of the Constitution. Here you can see the response of Justice R.F. Nariman and the response of Attorney General K.K. Venugopal. And what is more serious is that more cases under Section 66A have been registered after it was scrapped than before. Here you can see the numbers. Prior to the scrapping of Section 66A, there were 229 pending cases. Since then, more than 1,307 new cases had been registered, of which 745 cases are still pending and active before the district courts in 11 states, and the majority of these cases were registered in Maharashtra, Jharkhand, Uttar Pradesh and Rajasthan. Here I have provided the list of other states also where cases have been registered under Section 66A after it was struck down by the Supreme Court of India. Okay, so this is the reason this section, the controversial Section 66A is in news again. Let's see what is this section is all about. Here you can see the journey of Section 66A. Please take a look. Now let's try to understand what is Section 66A all about. It was part of IT Act 2000, which is the primary law in India for matters related to cyber crimes and e-commerce. Section 66A was inserted in this act as a provision in 2008 through an amendment act. Under this Section 66A, any person who sends by means of a computer, resource or a communication device including mobile phones and tablets. Number one, any information that is grossly offensive or has menacing character. So the law, however, did not define what constitutes grossly offensive and menacing character, or any number two, any information which he or she knows to be false but for the purpose of causing annoyance, inconvenience, danger, obstruction, insult, injury, criminal intimidation, enmity, hatred or ill will persistently by making use of such computer resource or communication device. Here we need to remember few things. For the first time, causing annoyance, inconvenience and insult have been made a criminal offence punishable up to 3 years of imprisonment. However, these terms annoyance, inconvenience and insult have not been defined. Okay. Number 3, any electronic mail or electronic message for the purpose of causing annoyance or inconvenience or to deceive or to mislead the addressee or recipient about the origin of such messages shall be punishable with imprisonment for term which may be entered to 3 years and with fine. Here message which includes images, audio, video and text. Okay, so without defining terms like grossly offensive, menacing character, annoyance, inconvenience, insult, the lawmakers have left it to the whims and fancies of officials to interpret the way they want. So consequently, which led to the misuse of this particular provision to arrest and harass innocent citizens of India and violated the individual's right to free speech, which was guaranteed under the Article 19 of the Indian Constitution. Therefore, Supreme Court of India in 2015, in the famous case Shreya Singhal versus Union of India, please remember this, which is very important for your UPSC and other state services examination point of view. So in this judgment, the Supreme Court declared this controversial provision of the IT Act as unconstitutional. The judgment had found that Section 66A was contrary to both Article 19, free speech, and Article 21, right to life of the Constitution. The entire provision was struck down by the court. Further, the judgment and final order in the Shreya Singhal case had rendered all investigations, prosecutions and convictions based on Section 66A IT Act illegal, and it forestalled any use of Section 66A IT Act after the direction was rendered. Okay, so therefore, hence it is this particular law is declared as unconstitutional and null and void by the Supreme Court of India 6 years ago. And after that, government had appointed an expert committee, T.K. Vishwanathan Committee, which proposed a legislation to meet the challenges of hate speech online. So this is how the Supreme Court of India ensured online free speech by scrapping this controversial Section 66A in 2015. Despite that, until today, cases have been filed under this particular act and innocent people have been arrested and prosecuted under this particular act. That is the reason this particular section is in news now. Okay, this is a serious issue and which is very, very significant for your UPSC and other state services examinations.